All right. Good afternoon, everybody. This is a meeting of the House Criminal Law Subcommittee. We have a few bills on our agenda. And actually, we do vote on camera. Just wanted to make sure Delegate Williams, Young, and Bartlett are prepared to vote.
Mr. Chair, I'm not a member of this subcommittee. I'm just here in case.
Oh, excuse me.
Has questions.
You shouldn't have said anything. You might have gotten to sneak in an extra vote
Get
on
an extra vote in there.
Yeah.
Mr. Chair, I'm just loading up my computer. I'll be on camera shortly.
All right, here's Delegate Kaufman.
Can you remind us of the bill numbers for today?
Yes, I hope I kept my cheat sheet. And we're going to start actually with Steve Johnson's bill. You may recall this one from a earlier subcommittee meeting. This was the bill that was about letting aging police officers off the hook of the physical agility requirement that we put into law, I think, a year or two ago. And we heard some testimony from the chiefs and sheriffs that their assessments actually do scale. Their assessments do scale with the age of the officer. Is there any?
Mr. Chair, I'll move
Yeah.
unfavorable. Love the sponsor. Have concerns with the bill.
Okay. There's a motion
Second.
unfavorable.
Second.
There's a second. Delegate Erican.
Thanks. Yeah. So I want to understand. Does the sponsor withdrawing his bill? Because
No, he wanted to keep it in play, and I appreciate the discussion. You know, in fairness to the sponsor, I raised the chiefs and sheriffs response with him, and what he said was there was a lingering concern that because of there are a variety of assessments available to departments, that a department could choose the strictest or switch to a strict one in a way that would impact the officers. And it's a new law, so I said we'd keep an eye on it. And I think that's true. The point has been taken, and I think there was enough of a discussion on it. It was sent to subcommittee. We took a look at it. I think folks last time around expressed that it was interesting, but maybe we should wait for development of some facts before we act on it.
Okay, so I just want to make sure we're moving unfavorable against the desire of the sponsor, right? That's what's happening.
The sponsor would like us to pass the bill.
Okay, so I'm going to be a no on the unfavorable then.
That's fine. All right. Is there any further discussion on the unfavorable motion? All right. All in favor of the unfavorable motion, raise your hands.
Aye.
Are there any opposed? Okay. All right. Apologies to my seatmate, Steve Johnson. He sits next to me on the floor, but them's the breaks. Okay. We are moving on now to a pair of bills that were sent to subcommittee on a very similar topic. This is about alterations to the one-party consent laws and wiretapping in Maryland. We had two bills on this topic. One was from Delegate Simpson that sought to alter this from a felony to a misdemeanor. and we had another one from Delegate Grammer that sought to create an exception to the crime of wiretapping if it involved essentially a domestic violence or other type of crime. And then that bill, the Grammer bill, also added a provision that would allow this evidence to be brought into court. So those were the two bills. And so I talked to Delegate Grammer about this. Apologies to him. We're going to do this all on one bill. And I'll, unless people oppose the substance of the resulting bill, I would offer to move sponsors over. Both of these bills, and to be clear to the subcommittee, both of these bills, the House has passed in some form in prior years. I think I had probably both of them at one point, and both of them were running into the Senate having a lot of heartburn seemingly with the use of evidence for this. So I have a proposal here to try and take the spirit of what the two bills are trying to do and put it into one. So on the screen in front of you, this is what I am thinking. We would properly reclassify this as a misdemeanor. And I hope the Grammer bill makes clear that this is not just about that weird Andy Harris case, that this is actually, looking at some of the firearms offenses that people are trying to reclassify, this really doesn't make sense to be a felony in today's day and age. And so here's what I'm proposing to do with what Grammer was trying to do. Rather than list out an exception that says it's illegal wiretapping unless it's related to domestic violence, this would create an exception if you think you're about to become a crime victim, that it's not a crime for you to record you about to becoming a crime victim. And we don't need to say what those crimes are. If we want to look at the Grammer list of crimes, we can go back to that, but this is what I thought was a cleaner way of doing this. And it's not as important to list the crimes because I've not included Grammer's request for evidence exclusion. That part got us into hot water in the Senate, so I don't think they're ready for it. So that's the amendment I would propose. And I see some hands. Why don't we start with Delegate Grammer, since it's his bill, one of his bills we're talking about.
Yeah. So I actually like it. I think the language as amended really just ties up all of the exclusion for if a person's about to become a victim of a crime. I like it. That actually also ties up the admissibility of evidence pieces. I'm not offended by the alteration of the charge itself. I would comment that this bill was asked of me by Yosefi and his team. If he's here, if we could at least allow him to comment. Is Yosefi here?
Chris, is he here? I can't see the.
I'm sorry, I don't know that I see him here.
Yeah, so if he's not here, I have no problems with it personally. If we want to give this to Delegate Simpson, I know she's she's talked to me quite a bit about this issue. I would just say that if she's going to carry this one, I'm going to focus on some other things that frankly are a priority for my district. Do we have a part of the conversation about this particular bill was that the felony piece was the sticker in the Senate. Have they come around on that?
Well, they didn't move either bill, but my general discussions with them on this and a series of other bills like the spousal rape exception and some of the other ones it always seems to keep coming down to people wanting to keep things out of divorce and custody cases. And so I was trying to be sensitive to that concern.
Yeah,
Again, I don't know what'll happen, but this is just me trying to not send them back the same bill they said no to.
Right. And the last thing I guess I'll say is, I don't care whose bill we push, but we're running short on time, and it's going to be tough if this one gets put in a bind and we have to yank this one from the jaws of death again. So
Well, I'll tell you what then. Why don't we do this? We won't do a motion on your bill, and we'll hold it in lying in wait in case something weird happens. Does that sound fair?
well, I mean, we got to move one, right?
Yeah.
We don't have to kill mine.
I sent in, Grammar, I sent in amendments on another one of your bills. I don't know if you received them. So, we're trying to move your work product too.
I understand and I appreciate it. It's just a matter of like, what time do you have, Well, then I'll stop talking.
All right, Delegate Cardin.
Thank you, Mr. Chair. First of all, I love the concept, and I'm in favor of making this policy move. But 3 quick things. Number one, first of all, I don't think we worry about time. I think we do it right. If it takes it an extra year or whatever, it's not like we haven't had this policy like this for the last 50 years. So what's the difference if let's just get it right, number one. Number two, this would not allow the Andy Harris issue to actually be solved. You realize that? Because the guy there was no, right? So that's number two. And number three is I worry about there being sort of the lawyers getting the word out to people that all you have to do, the divorce lawyers and the immigration lawyers, all you have to do is feign some possible assault that's about to happen, and then you're in the clear for doing it, which, by the way, maybe we want to allow it. Maybe it should just be a sort of a facade. But that's I think what we're creating here by making it be that you have to believe, because all you have to do is say, well, yeah, I thought the guy was going to hit me, so I started recording. Well, why didn't you run away instead of record? I mean, I don't know. So I'm just putting it out there that I like it. I like what we're doing. Let's just be honest about it, though.
Delegate Erican.
Yeah, thanks. I have similar concerns to Delegate Cardin's concerns. This could be a potentially really big change for family law. It has a huge impact on potential family law cases as well. I see what you're trying to do here, where you're combining the two of them together. Also, on the Andy Harris thing, I think, the kid complained that he got a felony charge, and that's what he complained about. So if you're removing that, I don't see what else he would be complaining about. He was asked repeatedly to stop recording. So, I mean, in a private area. So, sometimes you play stupid games and you win stupid prizes. So yeah, I'm a little uncomfortable with making a huge policy change, frankly, without, I don't know, a work group of some kind to study the impact that it will have on custody and visitation. Because what if Cardin's right and people are just like, how they all of a sudden started putting peace orders on everybody, like everybody in divorce cases using peace orders now. Everybody needs a peace order. Like, are we looking at a situation where now everybody's going to be, falling down the basketball court, holding their ankles, videotaping each other? Is that going to help us or hurt us? I don't know.
So to be clear, this is just about whether someone can be charged with a felony crime if they're about to become a crime victim, whether that person could be charged with a felony criminal offense. We took out the portions about evidence admissibility and other proceedings.
Right. which is why I think we're on the right track. I just wanted to just think about it. I just.
You want to think about your vote, or do you want to think about?
No, I'm ready.
amendment?
I will tell you, I'm supporting this idea. I like it. I just am like, we may be coming back next year with unintended consequences. That's all I'm saying. That's.
Move favorable, Mr. Chair.
You mean the amendment?
On
You
the-
want to
on
move
the
the
amendment.
amendment? Wait, hold on. All right. One of the advocates would like to speak. Go ahead, Melanie Shapiro.
Thank you, Delegate Moon, and thank you, everybody, for including me and this conversation. So the Maryland Network Against Domestic Violence has taken a position of information on this bill. Our concern, and we have asked for a work group, and there is a Senate bill that's being heard, I believe, next Tuesday, that would create a work group regarding the wiretap to look at it. And there are some amendments to include the Maryland State Bar Association Family Juvenile Law section and some other individuals. But our real concern is some of the legal terms of art that are in there, like reasonably believes and the imminent language. And if a person, a victim of domestic violence who is suffering from post-traumatic stress disorder, has heightened senses of responses and record something because they might, in their position, feel that they're in imminent fear, they're subject to criminal prosecution. And while I don't think that that's the intention, one of the reasons for some of this language is because of that errant situation where somebody was charged for recording somebody. And so our position, which has been consistent, is that we would support a work group. We would like to be part of the work group. And we just think that that would be the better approach this year so that we can really understand the full scope. Obviously, we want for victims of domestic violence in those situations be able to record something and have it. But I'm also very cautious about the unintended consequence of an abuser potentially recording something and recording the response and having that be the evidence. Technology, I'm not a technology person, but technology is amazing what people can do, and how we're going to make sure that that's not something that's being recorded by, the response from a victim isn't going to be what's captured and then used against them in some kind of proceeding. And I understand some of the evidence is taken out. I just have reservations with doing it this way this year. And I appreciate the amendments. Okay.
Right, that's very interesting. Are there any other, were there any of the other advocates on this bill that wanted to chime in?
Mr. Chair, can I just ask Melanie if she knows where that is in the process in the Senate, that bill?
So the bill hearing is today on the cross file for the imminent, the recording in the imminent danger situation. And I believe the work group is this coming Tuesday. And my intention, I did testify on this bill. I did written testimony, but I am testifying today in the Senate because I want to highlight, because I know where we are in timing, that we would really like that work group bill to move forward. I've testified that, this bill's been around in various forms for several years now. And I do think it's something that needs to be addressed. I just think that getting all the parties together to work out all of these concerns.
Thanks.
So sorry, let me just be perfectly clear then about what we're talking about. The work group bill that you're talking about is its own bill. It is a different bill than
Correct.
the cross file to Grammer's bill.
Correct. The cross file to Grammer's bill is being heard today. There is a separate work group bill that is being heard, I believe, next week.
Okay.
And they're both sponsored by Senator Folden.
All right. Well, that's interesting. Well, and so sorry. And the work group scope is about wiretapping inclusive of things like the Andy Harris situation, or is it domestically related?
I am looking quickly, but I believe it was looking at wiretap in general.
So it could be.
Yes,
Right.
Maryland Wiretap and Electronic Surveillance Reform Work Group. It's SB 754. Its hearing is 3/14. I don't even know what day that is. To study the effectiveness of Maryland's wiretapping and electronic surveillance laws. And then the report would be due December 1, 2024. So.
Okay. All right. Well, you know what then? This is what I'm thinking. That would suggest to me that the cleanest vote today we could take is just on the felony misdemeanor question, and we ought to push off the more substantive discussion on the decriminalization and evidence. Though I had already thrown in the towel on dealing with evidence this year, to be clear. Okay, well, then I guess we're talking about Simpson's bill as introduced. It just makes it just changes it from a felony to a misdemeanor.
Would it be possible, Mr. Chair, if in some amazing way that work group bill comes across, that maybe we could if we pass the Simpson bill, that we could bring them together and make it in turn.
We can redesignate the cross, but remember, we'll also be hanging on to Grammer's bill over here.
Sure.
Yeah, so I think we'll be with options. I think we can let this story play for a little bit. I would like to move the misdemeanor reclassification.
Move favorable
on the Simpson bill. Yeah. Second.
All right. Is there any further discussion on the reclassification? All right. All in favor of changing this to a misdemeanor, raise your hands. Are there any opposed? Okay. All right. Let's see. Next, what are we dealing with? We've got. Let's do facial. Chris, do I have facial recognition teed up next? Is that
Yes,
right?
I believe so. Correct.
Yeah. Okay. All right. So we're not ready to vote this, but I just want to let people. This will be news to actually all parties involved. But here's where I'm at. I had a chance to talk to Senator Sidnor and others over the last few days, and I've taken a look at what are alleged to be this is our final deal amendments from the various parties. And I don't want to come back here and do this again another year. And so I'm determined to get a bill over the line that is hopefully palatable enough to folks to move. And I think we're pretty close. So here's the kicker. OPD, and I know some other folks did not want social media data included if it was scraped from the internet, which is basically the major vendors doing this. And I have to be perfectly frank, this bill doesn't really make sense to do if we're not including those vendors and that information. And I talked to Senator Sidnor about this, and I think he understands that perspective and asks that if that's where we're headed, that we put on some very clear transparency and reporting on what vendors we're using, what databases they're using, and in what manner was the data gathered. And then probably after that, it's going to be on the courts to look at whether terms of service violations and things of that matter are relevant on this issue. So, okay, we are now talking about allowing the January 6th style technology to be used in Maryland for law enforcement purposes. So that's the big part. Now, further, we would have the Police Standards and Training Commission create a training and proficiency regime, annual training and proficiency regime for the people doing this work by June 30, 2025. And the Maryland State Police would come up with the statewide rules for facial recognition technology. So that's the big context, top line stuff that hasn't been put into words yet. And with that framework, the question then becomes, okay, we're doing this. We're doing this hopefully transparently. Then what crimes should we allow this very powerful new technology to be used for? And Chris, if you could put up on the screen now, the table, you will see up here a table, and it has what OPD wanted the list to be, and it has what the law enforcement folks wanted it to be, and it has what I'm going to propose we do. So if you look here, everyone agrees you can use this for crime of violence. Everybody's agreeing you could use this for human trafficking. Everyone agrees you could use this for first or second degree child abuse or child pornography under 11-207. Now, hate crimes. OPD wanted to limit this to hate crimes involving a felony or a death. And law enforcement wanted all hate crimes. I would propose we just put back, if you're doing a hate crime on a church or other religious institution, put that back in. Weapons offenses, look under there. You have public defenders wanted it for crime of violence. Law enforcement wanted all weapons offenses. I just took a quick scan through the code, and these were the ones that seemed to jump out as something more than just an ordinary wear carry violation. Animal cruelty, the OPD wanted just the aggravated offenses, which is like bestiality and dog fights, or mutilation. The law enforcement wanted to add in poisoning and abandoning pets. I talked to Senator Sidnor, and we are talking about just leaving this for the aggravated offenses. I think that's, is there more on the second page, Chris, or is that it? Here we go. Yes, there is more. So here's one for discussion. Fentanyl. OPD wanted nothing in there. The law enforcement wanted fentanyl dealers in there. And this, something along the lines of a fentanyl dealer who caused an overdose death. If that's what you're investigating, someone's selling bad drugs, basically, that caused a death, that would be in the bill. So that's, I guess, the state of play. I'm sort of at the point where I kind of want to press a proposal because we're on multi-years here and we're about to run out of time again. Delegate Erican, you have your hand up.
Yeah, great work. I mean, it sounds like we've got a good compromise on literally every topic here. I think I'm comfortable with all of them.
Do any other members want to weigh in on this framework, Rammer?
Can we add kidnapping?
It's a crime of violence.
Okay, 10-4.
Do any other members have any concerns about proceeding with something like this approach?
Can I just ask a quick question, Mr. Chair?
Yes.
Is there, are we creating just bureaucratic difficulty by making this, by sort of cutting, by surgically creating different crimes versus just making it a blanket? Again, I prefer the compromise, but I don't know if we're handicapping it and making it impossible to be effective. I mean, maybe there's something for
yes, we are. But let me give you the national policy context. Other states are outright banning use of this technology. So that's, or putting moratoriums on it. So that's what the other world looks like. And frankly, now that law enforcement is using this, turn around. I think you'd be surprised to see how widespread the use of this technology now is. I think we're causing a little bit of a chaotic situation by having wildly varying discovery data sets. What does the formatting for all this look like? I think it's better for all parties involved if there's some predictability as to how this is used, whether or not we restrict the crimes.
Question. But on Delegate Cardin's point, does any state allow for expanded use based on the acquisition of a warrant? Like if I have a particular crime and it's not on the list and I'm like, wow, I could use it here for this particular case for some reason, that could help cut through that bureaucratic mess if I could apply to actually get a warrant. Does anybody do that?
I don't know the answer to that, but I actually am also not sure that another state has done a framework on this yet. You know, we'll hear from a couple advocates for a split second next. We just have a couple minutes, so let's just get any more, because basically we need thoughts that are going to guide any, if people are going to have a problem voting on something like this, we need to know now because we're running out of time.
Yeah, that's the only one I have. And if you look at these Fourth Amendment bills, they tend to end with a catch-all clause to say, and if they get a warrant for that. So I would only raise that.
All right, so we'll flag that for discussion. Anyone else with any other? Yes, Delegate Embry and then Young.
I don't think there's time today. I guess when I read this bill, I wonder what exactly is the problem that is trying to be solved. I get the accuracy and I understand the verification and training. That is crystal clear to me. But the limitation on crimes and some of the other aspects, I just don't fully understand what exactly is the problem we're trying to solve. But I don't want to take up the time today, so I'm happy to talk about it.
Yeah, well, I'll just flag for you some of the concerns. This data was grabbed. So the original bill said you couldn't use it if the user data was unauthorized access. And I think in this instance, both Facebook and Instagram and the users in their pictures have not authorized that vendor to use this data in this manner, which there's actually federal crimes against terms of service violations, which is an interesting issue. But again, I really think this is going to end up being something federal courts probably look at down the road, and whether we want to step into that question, I don't know. But we certainly invite all sorts of constitutional questions and challenges. I think with the anything goes framework we have now. I mean, one of the interesting high-profile cases from Montgomery County involved a pretty petty, using this for very petty offenses, you know, and I think that's where you start to raise questions, you know, do people actually, are people okay with law enforcement dragnetting everyone's social media data against their wishes and then using it for enforcement of, I don't know, jaywalking or, you know, solo cop offense, you know, people at a spring break party. I mean, I don't know. I'm not saying they would use that, but that's the sort of gut check this bill starts to put into place. Should there be limitations?
Why not just start with one?
What's that?
I'm sorry.
So,
All right, Delegate Young wanted to speak. Go ahead.
Yeah, just quickly, the fentanyl piece I kind of find difficult to reconcile. You know, you don't go and buy fentanyl on the street. You buy something laced and it's laced with fentanyl. And so I just don't know. I mean, I'm not aware of investigations that, you know, where you're trying to find an individual dealing in fentanyl, so to speak. You're dealing in other things. So I just wonder how that works. I mean, I can wait and maybe ask a background question later on, but that's just kind of my thought process on how that actually looks in practice.
All right, last two, and then we'll have to move on. Grammer and Erican.
Yeah, there was a Supreme Court case recently that examined mens rea of violations of gun possession. And in that particular case, they had used something very similar to this, find someone who was shooting at a cop from their car. And so this is one of these cases you could use these technologies for. That's why I find it's very relevant.
Delegate Erican.
Just on the fentanyl piece, I think it's important to include it because people are selling dirty drugs essentially, and it's killing people in a way they didn't 15, 20 years ago. So I think if anything, it's going to tell dealers, check your supply before you dump it on the market, because if you don't check your supply, they can test their supply, and they should be. If they're, you know, I mean, they're drug dealers, but if they're even a little bit responsible, they should check their supply to make sure what they're giving out to people isn't going to cause them to drop dead. If they're not doing that, then we're going to use this technology and we're going to find you. So, but I do like putting some restrictions on it because I don't want to see what the vice chair said, solo cup charges coming from, you know, scrolling social media. That's creepy. And I don't think we want to go that direction as a country.
All right, that's enough. And so sorry, we brought all the advocates and law enforcement folks here to hear the state of conversation. We will have this moving in writing to share with you all soon. So if you want to do some lobbying to undo some of where we're headed, this is your notice that this is what's happening. Members, let me just also say, because of how long and complicated this negotiation has been, we're not going to be voting on single crimes to in or out of the bill. We're going to talk about this as we've just done. I hear a flag about the fentanyl question, and we are going to present one amendment that includes the negotiated list that we are all going to live or die by and send to the floor without changes. Okay. I just want to be, because we can just be in silly land otherwise with this, and we're not doing that. Okay. We have 5 minutes left to talk about Nicole Williams' bill. Delegate Williams, you have 1 minute to remind us what it is, and then we're going to hear 2 minutes each from the proponents and opponents about what changes might need if something were to move. All right, let's go.
Okay, really quickly, what this bill does, it just basically allows law enforcement to have another tool in their toolbox in terms of trying to track down someone in a missing persons case if there's exigent circumstances, allowing them to be able to ping the cell phone of the missing person in an effort to try to locate them. I know this is my second year bringing this bill. There were some concerns that were raised. You should have the amendments, which hopefully address a lot of the concerns that were raised by the advocates. My understanding, all of the cell phone providers are okay now with the bill. We tried to address some of the concerns that were raised by the ACLU with regards to the bill. I didn't have a cross file this year. Last session, my cross file was Senator Bailey over in the Senate. So this is a bipartisan bill. I think the FOP was in support of this bill. And so that's the gist of it.
And so, sorry, you said you've sent amendments.
There is an amendment to this bill. Yeah, it's only one. It's amendment 723425/1. That was sent a while
does it do?
ago. The amendments hopefully address some of the concerns, like I said, that were raised last time by the ACLU and some others. Also, the cell phone carriers had some concerns with the bill last time, so they're okay with the amendments, is my understanding. So it just puts, I guess, a couple extra guardrails on the bill. So it basically states if the electronic device was used to place a 911 call requesting emergency assistance during the preceding 48 hours, that's a circumstance. There has to be reasonable suspicion that the electronic device is in the possession of the individual involved in the emergency situation that involves the risk of death or serious physical harm. Also, the law enforcement officer may not request information from a service provider if the law enforcement officer knows the owner or user of the electronic device has not been reported missing. The law enforcement officer, and then it just gets into the penalty portion, which would be a misdemeanor not exceeding 6 months or a fine exceeding $500 if the law enforcement officer violates this section or uses it inappropriately. I think that was one of the concerns that was raised. Let's see here.
Sorry, let's actually pause there. Delegate Grammer, you have a question or a comment?
Oh, no. Okay. Oh, thank you for whoever put the reprint up.
Yeah, and it looks like, I think we were trying to have the ACLU here. Does OPD?
I see OPD is here.
Is OPD here to comment on this one? Have you had a chance to take a look at Delegate Williams's amendments?
I'm not sure if we've seen these specific amendments, but I know that she explained what the amendments would do, and we were satisfied so as not to have any opposition based on that. But if, and I'm
happy to email you, Ms. Hilliard.
Yeah,
okay,
that would be great. But I believe that everything you explained to us assuaged our concerns, so we were withdrawing any opposition.
Okay, and Delegate Williams, I did get a text from the ACLU earlier today that I think they may have had concerns but couldn't make it. I don't know if they've had the opportunity to see these amendments.
I thought I sent these to them when we first did them, but I'm happy to email them again to both them and Ms. Hilliard, just to make sure that they're okay with the amendments. That's not an issue at all.
Okay, well, I'll tell you what, we're almost at time, but we're coming back in a few days to vote anyway on a few more items. So can you just make sure to circle back that the opponents have seen that language and are okay with us moving on it next
Okay.
week?
Sure.
All right, that's it. And again, folks, we're gonna try and move that facial rec bill next time we meet. So in the manner described. So you have a few days